This video continues the first part of the History of Intellectual Rights series. Intellectual rights history is a broad and complex topic, so we will continue the approach step by step. Thank you for subscribing to the channel. Development of modern intellectual property rights. Patents. Patents are rights granted to inventors for their novel inventions. They give the inventor exclusive rights to make, use, and sell their invention for a limited time period. Example, Alexander Graham Bell's telephone patent in 1876. This patent gave Bell exclusive rights to the telephone technology for 17 years, allowing him to build his company, Bell Telephone Company, now AT&T, without immediate competition. Copyrights. Copyrights protect original works of authorship, such as literature, music, and art. They give the creator exclusive rights to reproduce, distribute, and adapt their work. Example, J.K. Rowling's copyright on the Harry Potter series. This allowed her to control the publication, translation, and adaptation of her books into movies, preventing unauthorized use of her characters and stories. Trademarks protect words, phrases, symbols, or designs that identify and distinguish the source of goods or services. For example, the Nike swoosh logo. This simple design is instantly recognizable worldwide and legally protected, preventing other companies from using similar designs that might confuse consumers. Key historical milestones. The Statute of Anne, enacted in 1710, is considered the first valid copyright statute. This British law granted publishers rights for a fixed period and recognized authors as copyright owners. Before this, the Stationers' Company in England had a monopoly on publishing. The Statute of Anne broke this monopoly and allowed authors like Daniel Defoe to benefit directly from their works. The U.S. Constitution and the Copyright Act of 1790 were pivotal moments in intellectual property history. The Constitution empowered Congress to grant patents and copyrights, which led to the passage of the Copyright Act of 1790. For example, this act allowed Noah Webster to copyright his famous dictionary. This not only provided him with financial benefits, but also encouraged his continued work on American English. The Berne Convention of 1886 was a groundbreaking international agreement. It governs copyright and requires member countries to recognize the copyright of works from other countries. For instance, a French author's work became automatically protected in other member countries without the need for registration in each country. This greatly simplified international copyright protection. The 20th century saw significant developments in intellectual property rights. These changes shaped the modern landscape of copyright, patent, and trademark laws, making them more relevant and adaptable to the rapid advancements in technology and globalization. World Intellectual Property Organization, or WIPO, was established in 1967. It is a United Nations agency that promotes the protection of intellectual property worldwide. For example, WIPO administers the Patent Cooperation Treaty, which allows inventors to seek patent protection internationally through a single application process. Trade-related aspects of intellectual property rights, commonly known as TRIPS, is a 1994 agreement that sets minimum standards for intellectual property regulation in WTO member countries. For instance, TRIPS required all member countries to provide patent protection for pharmaceuticals. This led to significant changes in countries like India, which previously only allowed process patents for drugs. The digital age brings its own set of challenges to intellectual property rights. The rise of the internet and digital technologies has made copying and distributing copyrighted material more accessible than ever. For instance, the Napster case in the early 2000s, in which the music industry sued the file-sharing service for facilitating copyright infringement, highlighted the challenges of protecting intellectual property in the digital age. This movement promotes freely sharing and modifying software source code, challenging traditional copyright models. A great example is the Linux operating system, developed collaboratively by volunteers worldwide, which demonstrates an alternative model to proprietary software development. Current debates in intellectual property rights include balancing innovation incentives with public access to knowledge, the impact of patent trolls on innovation, the ethical implications of gene patents, and the copyright issues surrounding AI-generated works. The history of intellectual property rights reflects ongoing efforts to balance the rights of creators and inventors with the public interest in access to knowledge and innovation. As technology evolves, intellectual property laws and practices must likely adapt to address new challenges and opportunities. Thank you for watching.